case only needs to be registered. Acquisition for the purpose of realization. So under close, NPA and securities have been taken over. How much time the company gets? Company has to complete the process within 5 years. So 5 years important. So the assets can be taken over. Say suppose it is the asset of a corporate borrower. The asset reconstruction company need not necessarily sell it. It can change the management of the business of the manager, and it can continue the business to lease or sell part of the whole business. The company can be leased to somebody, or the company can reschedule payment. The asset reconstruction company can reschedule payment. Take possession of security, enforcement of security as per SARFAESI. Last part, enforcement of security. That is, it can give a notice and take over the security and sell it also. But it need not necessarily do it. That is the middle part, reconstruction of financial asset. It can give this financial asset taken over on a lease to somebody and realize the money. So that is what is called the reconstruction of financial asset. Settlement of dues payable by borrowers. Now, dispute between are settled. With dispute, bank and securitization company, there could be problem, there could be dispute. QIBs, qualified institutional buyer and securitization company. These two companies, if there are problems, they should not go to court of law because it is time consuming. They should go for arbitration and conciliation. There is a law, arbitration and conciliation. So they should decide for an arbitrator. What is an arbitrator? We will give the problem to a mutually agreed arbitrator. Arbitrator will give a decision. Both parties will agree. That is what arbitration. So there is a law in our country to tell us how the arbitration should be carried out, how the conciliation should be carried out. So it's a very important point, because the dispute between bank and the asset reconstruction, between the QIBs and the reconstruction company, it is not settled in the court, but it has to be settled by arbitration. We are talking about enforcement of security interest mortgage on a property. So I have created a security interest. So how to enforce it? It's a floating charge. How to enforce it? Gives overriding power or provisions of Transfer of Property Act. That means if there is a clash between the provisions of Transfer of Property Act, because mortgage is always created under Transfer of Property Act, and SARFAESI Act, the provisions of SARFAESI Act will have precedence. It will overrule the provisions of Transfer of Property Act. Important provision, important point for the question paper also. Now, what is the first point in enforcing the security? Now we are coming to what the bank does. An account goes back, we want to take over the security and sell it. What is the process? So till now, we were talking about how an asset, NPA, is transferred to the securitization company. So once the securitization company takes over the asset, the process being done by the bank for realization and the process that's being followed by a securitization company for realization, they are same. Both uses provisions of section 13 of SARFAESI Act. So this is a common process. If the bank itself starts initiating the process, we will have a process. We have already handed over to asset reconstruction company. They are going to realize. They will also use the same process of SARFAESI. So let's understand. First point is a demand notice is given to the borrower and guarantor or obliger. Okay, obliger. So minimum scale for officer has to be designated for this purpose. He has to sign. The notice is given under which section? 13 subsection 2. Important. You must remember 13 subsection 2. Because the first notice is given under section 13(2). Now, once the bank has given that notice, then the borrower cannot transfer that property afterwards to anybody. Very important point. It cannot transfer. Only assets classified as NPA is eligible. First, it should have been classified as an NPA as per the RBI guidelines. Those accounts only can be taken up for enforcement of securities. Okay, now you have given the notice. The borrower has to settle the dues within 60 days from the date of notice. It's not 60 days from the date of receipt. 60 days from the date of notice. Take note, important point, examination. So what is the effect? Bank has to wait for 60 days after giving the notice. If the borrower has not come, we can take the next step, or borrower can within that 60 days give objection saying that what you are not doing is proper, or I have not defaulted. Borrower has got a chance. If we are getting an objection or a letter from the borrower within 15 days of receipt, we are required to reply. So next, first is 60 days, another is 15 days. Now, next process, suppose let us imagine that for 60 days he has not come. So we have to take possession of the secured asset of the borrower. Let's say a house is mortgaged to us. We have to take possession. Not only take possession, if we want, we can lease out. If it's a company, we can lease out, take over. We can take over the management of the company. We can appoint a person to manage the security. Issue notice to the person who acquired the security from the borrower to pay dues to the creditor. That is, somebody has taken that property on rent. It's a go down, somebody has taken on the rent. The bank can give a notice to that person to give the rent to the bank. Transferee gets all rights from the secured creditor as that of the borrower. That is, if the securities are transferred to a securitization company, that transferee gets all the right which was originally with the bank. So possession notice. Next is possession notice. So we have seen possession notice means we have to take possession of the property. But sometimes it is not possible for us to physically take over because some people may be living there. So what we will do, we will take symbolic possession. What is meant by symbolic possession? We will paste a notice in front of the house, or if it's a barren land, we will take a board and we will have a board there saying that bank has decided to take possession. All this will be there. That is a standard notice as per section 34. So once we have pasted that notice, within 7 days, I repeat, within 7 days, it has to be published in 2 newspapers. One should be vernacular, that is local language newspaper, and another copy should be in English newspaper. Important provision. So once you paste, that means you have symbolically taken over the possession. Within 7 days from that notice date or the date on which we paste, it has to be published in a newspaper. 2 newspapers, one vernacular and one English. So we have completed symbolic possession. Next is we have to sell the property. We have to give a notice afterwards to the borrower that we have decided to sell. That is the sale notice. For that, we have to give 30 days time. Allow 30 days time. That means we have pasted, the customer has not come. We have decided to sell. We will give the notice, but that notice, we have to wait 30 days after the sale notice. So first 7 days, then next is 30 days. If after 30 days, we can auction sale is permitted. E-auction. Now it is electronic form auction is preferred. Before confirming sale, the borrower has option to redeem the security by full payment. That means we have proceeded. We have kept the property for auction. When you are about to auction, start the auction, the borrower comes running, says, "Sir, here is your money. You give the property." Can the bank say, "We have already proceeded. We are about to sell. You should have come early"? No. Till the last minute, the property is sold. The customer has a right, the borrower has a right to come and redeem his property. That is the meaning of before confirming the sale, the borrower has an option to redeem the security by full payment. Sale is based on reserve price. So you should know what is reserve price. We have decided to sell a price. We cannot sell it for any price. There is a procedure laid down. That is, we are supposed to have a panel, experts. That means not the normal, our architects, which we appoint. At the higher level, it is to be, a panel is to be kept. So they have to decide at what price this can be sold. To have transparent, and that is to be approved at a high level, and that price is called reserve price. So we decide to auction the property. So we will have to say this is the reserve price. Say 25 lakh is the reserve price. So those who are bidding, they cannot bid below that 25. If there is no offer of 25 or above, we will not conduct the auction, because this is to avoid collusion between banks and others. The customer tomorrow can say, I would have got 30 lakhs, but the bank sold it for 20 lakhs. So we have to identify, we have to decide what is the reserve price, and that reserve price needs to be communicated to the borrower, so that if he wants, he can pay that money and take the land. There's no problem. Appropriation of sale proceeds. This also is a very important point for the exam. Okay, you realize the money, you sold the property, you realize the money. That money that you received, in what order it should be apportioned, how it should be adjusted. First, we will adjust towards cost, charges, and expenses towards protecting of the property. Sometimes we would have taken insurance. Sometimes we should have appointed a security agent. So first, we will recover that money. Secondly, towards settling the dues of the actual NPA, that of the bank. If there is a surplus left, after adjusting this, the balance amount has to be paid back to the creditor, to the owner of the property, to the borrower. Okay, remember, after recovering our dues, if there is any amount left, that is to be repaid to the borrower. If under consortium, creditors of 60% value should agree. That is, there are 4 banks. So if you want to go under this SARFAESI proceedings, it is not 60% of the number of banks. Say there are 5 banks. Between 2 banks, they are holding 65% of the total NPA. Then those 2 banks can decide, and others have to fall in line. That is the meaning of that. If the borrower is a company, suppose sometimes the property taken over belong to a company, dues payable to the worker who have pari passu charges with secured creditor. An important point, please understand this. What is a pari passu charge? Pari passu means we have a property. We have a pari passu charge between State Bank of India and Canara Bank. Means after realizing that money, Canara Bank and State Bank has to share equally. Equally means according to the proportion of their NPA. Suppose 100 crores, Canara Bank has 60 and State Bank has 40 crores. If 100 crore is realized, 60% should go to Canara Bank and 40% should go to SBI. This is the pari passu charge. First mortgage, second charge mortgage. Let us imagine Canara Bank has the first mortgage and SBI has the second mortgage. In that case, the Canara Bank will first use the money to settle its dues completely. If there is anything left, only State Bank will get. In pari passu, because the mortgage was created pari passu, according to their share of the debt, that will be shared equally. That is pari passu. So what is the significance here? We got, say, 25 lakhs after selling the property. The company, as per the company's record, there is a 5 lakh which are due to its workers. So bank has got 25 lakhs. So bank has got 25 lakhs NPA. Bank got 25 lakhs. 5 lakhs workers. So can the bank take the entire 25? Because it's a pari passu charge according to the law. So 25 is to 5 will be 5 is to 1 now. 25 is to 5. So in that portion, this 25 lakh is to be given. The workers may not get entire 5. But 5 is to 25. That proportion, this money realized, is to be split. We cannot say it is our own money. It was mortgaged to us. So we have a right. This exception is only in case of workers' dues. Suppose the sale tax department says the property is mortgaged to us. We have realized using SARFAESI. I got 25 lakhs. The sale tax department gives us a notice saying that this company owes 5 lakhs to us. It's a government dues. You have to give 5 lakhs to us. No, we will give only after realizing our full amount. We will take our 25 lakhs. If there is a surplus left, then we will give to the government. But the workers' dues, it is only different because it is pari passu. If the dues of secured creditor are not fully settled, you can proceed through DRT civil. That is, our NPA is 25 lakhs. We used SARFAESI and we recovered 20 lakhs. So we have 5 lakhs left. We recovered only 20 lakhs. For this 5 lakhs, we can file a suit separately in DRT or civil court as the case may be. These are all important questions because they will say after using SARFAESI, you have recovered 25 lakhs, 5 lakh is left. Whether for that 5 lakhs you can file a suit. If the dues are secured, creditor not fully settled, you can proceed to DRT civil court. All actions to be within limitation. That is, if the documents are time barred, you cannot use SARFAESI for a time barred debt. When we give notice under section 13(2), our document should be live. If takeover of management notice to the directors of the company, we have told that instead of selling, we may take over the management of the company. Bank can take over or the securitization company can take. In that case, we have to give a notice to the directors of the, if the borrower is a company, notice to be published in newspaper for taking over of management. That is, if we are taking over management of a company, we have to insert an advertisement. The directors are deemed to have vacated their office. Once we give the notice and take over, the directors have left the office. Secured creditor can appoint directors, shareholders can also appoint directors. Resolution by share only with approval from secured creditor. That means once the notice is given, nobody can enter into a compromise. Winding up an appointment of receiver by court with the consent of secured creditor. That is, if a liquidator is appointed, he has to act as per the consent of the secured creditor. In preparation of inventory, not only immovable property, we can also take over movable property. That is, say some rice is hypothecated to us. That also can be taken over under SARFAESI Act. So we have to first prepare the inventory. How many sacks, how many kilograms of rice is there? We have the responsibility to protect the property or the goods that we have taken over. Suppose we have taken over a property or a good which is going to be perished. For example, we have taken over, say, vegetables. 2-3 days it will go. In that case, we don't have to wait for further proceedings. We can straight away sell it. Otherwise, we have to give notice. The due process is there. So we have to remember, if it is a perishable goods, immediately it can be sold. Sell the property to the highest bidder, the bidder. Now, we have to have a witness. We prepare a panchanama, that is the details. That is for the hypothecated goods. But once we have auction, this what we are going to discuss about the auction, that is true of mortgage property, immovable property also. That is, the person who is buying the property has to give 25% of the sale price immediately, upfront, first day. The balance amount can be given within 15 days. 5 lakhs, if somebody is taken over, 10% of that, 25% of that needs to be paid immediately. The balance amount within 15 days of the, so if he fails to pay, he will also lose this 25%. Authorized officer will issue the sale certificate. So the bank's authorized officer can issue a sale certificate after auction. That gives a title of property. Since it is a transfer of immovable property, it attracts stamp duty. Hence, it requires stamping. If the borrower objects to taking possession, so we are talking about taking possession. We are going back. We have told that we have pasted the notice, but some people will be staying inside and we will have problem in physical possession. We have taken only symbolic possession. While taking possession, we may find opposition. We might get beaten up. In that case, we can file a petition. We can give a request to Chief Metropolitan Magistrate or District Magistrate. Once we give a request, within 30 days, it was not there earlier. It is not mentioned here also, I think. So within 30 days, the Chief Metropolitan Magistrate has to issue order saying that police assistance should be given to the bank to take possession. If due to some technical reason or another, 30 days it cannot be done, then at best 60 days it should be given. So this is a provision added because the banks used to give application, this district magistrate, they will never take action. So now SARFAESI is amended and it has become mandatory on the part of district magistrate to act within 30 days of receipt of request from bank or financial institution. And the action of district magistrate or metropolitan magistrates cannot be questioned in a court of law. They are protected. Borrowers, suppose aggrieved person can prefer DRT with fees. That is, you have given notice, you have decided to sell the property. At that point, the borrower objects. Borrower says it's not proper. Should we stop? We will not stop. But the borrower can file an application in DRT. Which court? Not in the High Court or Supreme Court, DRT. So that is to be filed within 45 days. You must remember 45 days of our sale notice. DRT to dispose of application as per DRT Act. To dispose of within 60 days. That means if the customer files an appeal in DRT, it has to be disposed of within 60 days. Extraordinary situation, 4 months. So that 60 days, we have to remember. 45 days, we have to remember. If not aggrieved, party can prefer appeal with appellate tribunal. That is, 60 days he has waited. The DRT did not act. Then there is an appellate tribunal or appellate court under DRT system, DRAT, appellate tribunal. Debt recovery appellate tribunal. So if they are not acting, the borrower can straight away go to DRT, or DRT gives an order. It goes to the DRT. DRT gives an order. The borrower is not satisfied with the order of DRT. Even then, he can file an appeal in the DRT against the order passed by the DRT. Within how many days? 30 days. Within 30 days of the order by the DRT, he can go to DRAT and file an appeal. But there is a provision in the law. It should not be misused. The borrower has to deposit 50% of the amount, whatever the dues. SARFAESI, we have recovered or we want to recover. There is money payable by the borrower to the bank. What is the total dues? 50% of that needs to be deposited with the DRAT. DRT, that provision is not there. When the appeal is filed in DRAT, 50% should be deposited. And if the DRAT feels it can be reduced to 25%, can the DRT waive it? No. So that question can come. If the DRAT wants, it can waive the money that is required to be done. No. Mandatory is 50%. As per law, if the borrower is going to challenge, he has to deposit 50% of the dues in DRAT. The DRAT wants, it can be reduced to 25%. But even DRAT cannot say that he need not deposit the. There is a central registry. We call it as CERSAI, Central Registry for Securitization, Asset Reconstruction, and Security Interest of India. What is it meant for? All transactions relating to SARFAESI Act, they are to be registered with this CERSAI. We know we are registering our mortgage that we are creating in CERSAI. Similarly, securitization of financial asset. If a securitization company has taken over asset from the bank, that is to be registered with CERSAI. If the reconstruction, for the reconstruction purpose, if an asset is taken over, that needs to be registered with CERSAI. If you have created a security interest, that means if the bank is creating a mortgage over a property, that needs to be registered. Only if the charges are registered in CERSAI, we can use SARFAESI. Then only we can use SARFAESI to enforce it. Registry maintains a record. Earlier, there was a stipulation that within 30 days it should be registered. Now it is altered. The 30 days is not there. But the priority counts. Whoever is registering first, he should have first priority. The registry headed by a central registrar appointed by central government, supported by other officers, creation, modification, satisfaction to be registered. That is satisfaction also. If a loan is repaid, mortgage is released, that is satisfaction of charge. That needs to be registered with CERSAI. The person registering first will get priority. Satisfaction needs to be registered within 30 days. That means a borrower repays the money and the bank has to register satisfaction within 30 days. And if the bank does not register, the borrower can register also. The borrower can give an application, I have already repaid the loan, you please register my satisfaction. In that case, the registry will write a letter to the bank seeking clarification. The bank says, okay, he has repaid. Without the request from the bank, the registrar will record that it's already settled. Now, very, very important point, non-applicability. We have told about it can be used to recover our loan, but some exceptions. Pledge and lien, SARFAESI cannot be applied. Why? SARFAESI is applied only when the security is in the possession of the borrower. Mortgage, the property is with the borrower. Hypothecation, the goods or the vehicle is with the borrower. So we can use SARFAESI. Pledge, gold is pledged. It's with the bank. You have a lien over your deposit. It's in your possession. So we cannot use SARFAESI for the security that is in your possession. That is why we say it cannot be used for lien and pledge. Next important provision. Agricultural property you cannot touch under SARFAESI. Okay. Total dues are not exceeding 1 lakh. Minimum amount of dues should be 1 lakh. All are important from the question paper point of view. If the total dues less than 20% of principal and interest thereunder, that means outstanding dues are above 1 lakh. You have given a 1 crore loan. The borrower has paid towards interest and principal, say 90 lakhs. So your outstanding is 10 lakhs. Can you use SARFAESI? No. Why? Minimum should be 20%. That means your dues were 1 crore. If 20 means 100 crores, 20 crores. So unless the present day, unless when we are acting, the balance is 20 crores, you cannot use SARFAESI. General provision is 1 crore and above. But in this case, it is 20% of the total dues because the balances we have recovered already. Therefore, SARFAESI cannot be used. This is an important provision. Sometimes they will say this is the outstanding and this was the total dues customer paid. So now this is, it is above 1 lakh, but can we use the SARFAESI? No. Then SARFAESI cannot be used for vessels, aircraft. That is ship and aircraft. They are not covered under SARFAESI. Conditional sale, hire purchase, lease where no security interest is created. That is conditional sale. Somebody is holding a property. The sale is not complete. That you will understand when you study the module D. So it's not an honor. Then we cannot use. Hire purchase. Hypothecation, it can be used. Hire purchase, this cannot be used because hire purchase, the ownership is not transferred. Therefore, hire purchase, it is in your possession. So it cannot be used. Right of unpaid seller. When you study the module D, there is a right of unpaid seller. Your borrower is holding a property or a hypothecated good, but an unpaid seller's interest is involved. He is no doubt is in possession of the security, but another person who sold that, he has some interest because this fellow would not have paid fully. Such property we cannot attach under SARFAESI Act. Penalty. For adjudicating authority of powers to impose penalty. For failure to comply with any direction issued by RBI under SARFAESI Act, imposed on any such or person. That is, the RBI, Securitization Company, who is the authority RBI. RBI gives directive, just like to the bank. It is not complied. Then what is the penalty? Twice the amount involved in such failure, if quantifiable. That means, what is the amount involved? If it is quantifiable, twice the amount. 1 crore rupees, if it continues, rupees 1 lakh for a day, or 1 crore rupee, that is, if it is not quantifiable, 1 crore rupee, and if it continues, it is 1 lakh per day. If a person contravenes or attempts to contravene provisions of SARFAESI, we have given a notice. He is not supposed to transfer that property. The person ignoring the provision transfers the property. Then he is liable for imprisonment for a term which may extend up to 1 year with a fine or both. He can be slapped a fine, or he can be imprisoned, or he can be slapped the fine also. So we have come to an end of SARFAESI. So next we have to go to PRT. Okay. So we have taken one full 1.5 hours for SARFAESI because it's a long topic. So I think let's not take another topic today. If you want to ask any question on what we have discussed, let's do that.
Sir, please explain QIB. What is the function of QIB?
So,
okay. One at a time. One at a time. What is QIB? The asset reconstruction company takes over the asset from the bank. Bank is to be paid from where the asset reconstruction company will get money. Asset reconstruction company's capital cannot be used for takeover of assets. So this asset reconstruction company has to raise money from the market, like a company raising money from the market by issuing shares. So it has to. So the RBI has told that retail investors are not allowed. Now they are going to allow. Already SARFAESI is amended. So right now, retail investors cannot invest. So only QIB. What are the QIB? QIB are special institutions registered with SEBI for this purpose. So asset reconstruction company, it comes out with an offer document where all details are there, and it says we want to raise 100 crores, for example. Then it will split that 100 crore into small security receipt, maybe 1 lakh, 1 lakh, 1 lakh. And that security receipt, it's like a share that will be sold to QIBs. QIB will purchase that. When QIB purchase that, QIB's money will come to asset reconstruction company. Asset reconstruction company will use that money to pay to the bank. And then QIB will be holding security receipt. What asset reconstruction company will do? It will sell the security. It will get money. When it gets money, it will give to QIB along with interest, maybe 5 years. Then it will take back, like a debenture is taken back by the company. Same way, this security receipt will be taken back by the QIB, and the money will be given back to the QIB. So the entire cycle of transaction is over. So your question, what is the QIB? QIBs are institutions which are registered with SEBI, and they finance the securitization company to enable them to pay the bank the cost of assets taken over from them. Are you clear?
Yes, sir. Thank you, sir.
Okay. Any other question?
Sir,
So what's the difference between DR and DRAT?
Tomorrow we are going to discuss DRT. So the full discussion will be there. So let us not waste time now.
Okay, sir.
DRT case, if somebody gets an order, if he is not satisfied, he will go to DRAT for appeal. In a civil court, district court, you get an order, you are not happy, you will go to High Court with an appeal. DRT,
this is High Court and Supreme Court.
You go to DRAT. Anyway, we will discuss in detail tomorrow. Okay?
Okay. Sir.
Sir, in SARFAESI, we taken this physical position, symbolic position. Whether we have to apply for physical position to court, get the for support
whether
of the
whether we have to apply for?
Sir, in SARFAESI Act, we take under symbolic position.
I didn't get you. It's your voice is breaking.
So in SARFAESI, we take symbolic position.
Symbolic position, right?
Yeah, we taken symbolic position.
Yeah.
For physical position, we have to apply to court to get the permission.
I told you no court. You can take physical possession on your own. If you have any problem, you will give an application to the Metropolitan Magistrate or District Magistrate. He will give you police protection, and you can take it on your own. No court, nothing. Okay.
Support, na, sir, for that one. For police support, we did not. So we want to vacate the house means we need some police support, na, sir.
I told you, there is a provision. There is a. You listen to what I am saying.
Yes, sir.
There is a provision in SARFAESI itself. You will. We have already discussed this. You will file a request. You will make a request to the Metropolitan Court or to the District Magistrate. He is required to give an order within 30 days that necessary protection should be given to the bank. And if necessary, police protection will be given to the banker to take physical possession of the property. You don't have to go to the court. Are you clear? Are you clear or not?
Okay, sir.
Okay.
Sir, in DRT, you have explained like 45 days appeal. Can you just explain that again, sir?
Tomorrow, you will be clear. You can note down the question because we are going to discuss DRT. That is, DRT, you are getting an order. If you are not satisfied with the order, you have to file and prefer an appeal. So that is the 45 days. Anyway, we will, if you have still
Customer is going to file appeal, sir?
Yeah, customer is going to file appeal. Anyway, tomorrow DRAT, we will discuss. Still, you have any doubt, you just note down. You can even this question. Once I think DRAT, if we all these 45 days, everything is going to come there.
Okay.
But still, if you have issues with regard to this SARFAESI? Please ask. Okay.
Sir, and one more doubt, sir. In
Yeah.
ARCs, when we are suppose if they sell the property on behalf of the bank, if they are getting any shortage in the loan amount, then how that recovery will happen, sir?
You slept in between. We discussed this. We have told you, I gave you even an example. That means I told you the loan amount that we have to recover is 25 lakhs.
Yes, sir.
We took over the property and we recovered, sold the property under SARFAESI. We got 20 lakhs.
Okay.
There was a shortage of 5 lakhs.
Yes, sir.
For that 5 lakhs, you can file a suit in DRT or civil court as the case may be, because DRT minimum amount should be 20 lakhs. So you can file a suit either in a civil court or a DRT as the case may be.
Oh, that will be done by bank again, not from ARC.
No, if the ARC is handling, ARC will do.
Okay. Okay.
If you are doing, you will do.
Okay, sir. Okay.
Because once you have sold to ARC, then where is the question of you are getting balance amount? There is no question, because you have all the entire security, everything you have handed over.
Okay.
Then the question of you are having shortfall, nothing arises, because you have taken a conscious decision that you are 25 crores, you are going to sell for 20 to ARC. Then there is no scope of going to DRT. You got the point. Then
Yes, understood, sir. Now I understood.
okay, right.
Sir, in case of demand notice, sir,
Hmm.
that 60 days time from the date of issuance of the notice or from the acknowledgement.
Date of issue of notice.
Pakka, sir.
Date of notice.
But we have seen that from the date of issue of the acknowledgement, sir, from the borrower.
Where you have seen?
Actually, our bank, sir, we executed some
Our?
SARFAESI actions, sir.
Our?
No, we in present our branch, sir, we have executed some SARFAESI actions, sir. Actually, they told that
You have given time 60 days from the acknowledgement. There is nothing wrong, no? You can, minimum is 60 days from the date.
Yes, sir.
So
Yes, sir.
safer side, they would have given, because sometimes it's not received. He will deliberately, he will not receive.
Yes, sir. In that case.
So what we'll do, we'll again publish in the newspaper.
Yes, sir. Yes, sir. Yes, sir.
So we will not take the risk saying
Yes,
that
sir.
it's a dated. So we will give sufficient time.
Sir.
So that is the practical part of it. There is
Sir.
law and practice. Is not so.
Sir.
So
Yes,
we
sir.
wouldn't want to take risk.
Sir.
So we will always give that cushion. But
Yes, sir.
according to what I have understood, the law says 60 days from the date of notice. Anyway,
Date of notice.
I will check up, and if there is any change, I will tell you in the next class. Okay.
Yes, sir. Yes, sir. Actually, what will happen? So some borrowers will change the address, so they will not receive some.
No. They will not accept the notice
Yes, sir,
at
yes,
all.
sir. That is the thing, sir. Yes,
That
sir.
will come back to us.
Okay, sir. Okay, sir.
So
And,
the postman will write, the party not available.
Yes, sir. Yes, sir.
Yeah. So from then what we will do, we don't want to get into problems. So we will say 60 days, we will count from that. Normally this bank acts on 60 days. We will take 90 days. But this is a provision in the law. Anyway, if there is any change, I will tell you in the next class. Okay. Let us be clear on that. My understanding is like this.
Okay, sir. Sir,
Okay,
and
we will-
another thing, sir, in case of SARFAESI action, that only option is DRT or that borrowers will visit even High Court also, sir?
No, if it is a matter concerning this SARFAESI or takeover of property, it's only DRT. High Court and Supreme Court, sometimes people go. When violation of fundamental right is involved, he will say there was my fundamental right is infringed. In that case, he can go for a writ petition directly to High Court or Supreme Court. It has nothing to do with the recovery. What he will say, he will plead is people are going because to get stay. What they will say is the bank acted in a high-handed manner. So natural justice was violated.
Yes, sir. Yes, sir.
So I have a fundamental right to be heard. That opportunity was not given to me. Therefore, there was a violation of fundamental right, which DRT cannot deal with. In that case, the High Court will accept that writ and will dispose of it. That is why you would have come across in some cases, people go to High Court or Supreme Court.
Yes, sir.
But
Yes, sir.
that is only with respect to some constitutional provision for your fundamental rights. Are you clear?
Yes, sir. Yes, sir.
Sir,
Sir,
one
another-
small note. If
Hmm.
any stay comes in favor of the customer,
I didn't.
then
Can you repeat? Can you repeat? The first-
if any stay comes in DRT in favor of the customer, suppose if we are in a position, we are in the stage of taking possession, so that cannot be taken from bank, sir.
No, if he has got an order from the DRT, we will have to honor. We will have to. We will definitely file a counter. We will.
But in favor of customer stay has, so that time we are not supposed to go for.
Definitely not. Definitely not. Definitely not. Because DRT has jurisdiction. No, DRT says what the bank has done is wrong, or
Okay.
more time should be given. Then we will have to abide by that. No doubt on that.
Sir, and as you said, in ARCs and QIBs, how questions may ask, sir? Like which kind of questions they ask?
ARB is registered with whom?
Okay.
What is the maximum amount of own fund required?
Okay.
QIB is registered with whom?
Oh.
Then like ARB, lot of questions can be asked. Whether reconstruction, whether it can taken over the management of the part, and separate scheme is to be, separate trust is to be formed. Can they combine the account?
Okay.
So we have found that two separate scheme, two set of NPS are taken over means they cannot combine.
Yes, sir.
So all these are the main questions.
Yes, sir.
So this time bar document.
Pari
so
passu,
SARFAESI
sir.
also applicable, sir.
One at a time. Time bar document.
SARFAESI Act also applicable, sir.
Yes, sure. You can go for SARFAESI action only if the documents are live.
Live only. Okay, sir.
Sir, pari passu charge.
Pari passu means you have to compare with first mortgage, second mortgage. Suppose we have an account where one bank has first mortgage and another bank has second mortgage. Okay. So property, you have given 50 lakhs and another bank has given 10 lakhs. So 5:1. So you have given 50 lakhs, another bank 10 lakhs. You have the first mortgage, you have given 50 lakhs, other bank has given 10 lakhs. Here's the second charge. You got 50 lakhs after selling the property. Since you have the first mortgage, you will take the entire 50 lakhs and the bank with the second will not get any money. Okay. Now, what you created was pari passu charge. That means 5:1. So 50 lakhs you got as in the first case, and your outstanding is 50 lakhs. But you will not 50 lakhs because since it is a pari passu charge, you have to share with the other bank. So you have given 50, and they have given 10, 5:1. So this 50 lakhs that you realized has to be split at the ratio of 5:1. That is, out of 6, 5 portion will go to the first bank and 1 portion will go to the second bank because it's a pari passu charge. Are you clear?
Yes, sir.
Anything else?
Sir, both section 13.2 and 13.4 comes under Transfer of Property Act 1882.
I didn't get your question.
Sir, my question is that both the section 13.2 and 13.4 comes under Transfer of Property Act.
No, SARFAESI Act. So shall we close for the day?
Yes, sir. Yes, sir.
Have you got a fair
Thank you,
idea
sir.
about the entire thing? How the what is securitization? How the process is? How
Yes, sir.
the enforcement of security? Enforcement of security is important because that notice 7 days, 30 days, sale notice. All these stipulations are very, very important from the question paper point of view. Okay.
Yes, sir. Very clearly explained, sir.
Okay. Right. Thank you.
Good night, sir.
Good night.
If you like our content, do like, share and subscribe.